This lecture is Trademarks and Keyword Advertising. The agenda for this is to do an overview of Internet search theory to try and understand what it is that people are searching for when they search the Internet, because that interfaces, as we're going to see, with the law of trademarks and raises a number of interesting and important policy questions for the way that the intellectual property law deals with the Internet. And then we're going to look at the case of RescueCom versus Google, which is in the readings and is an important case exploring the Google AdWords concept, whether it's actionable trademark infringement, and looks at the specific aspect of the trademark use doctrine, which we're going to look at specifically as well, to discuss what is the underlying idea here on this requirement that there be a trademark use of trademarks in order for there to be infringement. And then we're going to go finishing up and discuss, now that we understand some of the aspects of the law, how search and trademarks interact in the online environment. So moving on, our first item on the agenda is Internet search theory. And I think one of the things to think about is understanding the process by which a user searches for something on the Internet. And this, if you read the readings on the search engines and think about what the search engines are trying to do, you know, this is sort of the process, right? So the user formulates some objective. What is it that he or she is searching for? You then select a search provider, whether it's Google, Bing, Yahoo, some other search provider. You select the keywords. What is it that you're going to type into the search box, right? You do so. You search, right? You get a series of results. That's step 5 here. You evaluate those results. You make a decision on which of the links to click, which looks like the most promising link, for example. You investigate it, usually by clicking on the link, going to that site, and then determining whether or not you've satisfied the objective. Did you end up finding the thing that you were looking for when you searched, right? From the provider perspective, right, what are they doing? They are aggregating as much information as possible. They are sorting that information. The information that they're aggregating is about what web pages are out there, what their content is. They sort it, right? They sort it into different categories. They sort it by a number of important algorithms, and they filter content, for example, and determine what you know, by virtue of what the user inputs into the search box, they then return some of that content that might be relevant to the search. Often, most search engines will reinterpret the search or keywords. So if you type in McDonald's, for example, it'll interpret your keywords as not only searching for McDonald's restaurant, but maybe more generally the idea of fast food restaurants, maybe the idea of McDonald's, the name. So it will reinterpret your keywords in a variety of ways to try and satisfy the objective that you have. And then sometimes they edit publisher content by, in some sense, eliminating certain types of materials that are otherwise in the search engines, including some even in categories they might not seem most relevant to, depending on the particular situation. Right? The key issues involved here for search engines, and that end up being very important, are that the objective of most searchers, certainly from the perspective of the search engine, are relatively opaque, right? It's relatively unclear, and they certainly can't talk to or interview the users of the search engines. It's pretty unclear as to what exactly the searchers are looking for, what their objective is, right? And the other issue, and so because of that, you know, we have to think about how the law of intellectual property, the law of trademark, operates, right? Because we have this idea in trademark of the way that there's a connection between marks, between the idea of a word or a logo and the underlying source identification. Now, in the internet context, it might be more difficult to know whether or not when somebody says, I'm looking for Mercedes, what they mean by that, right? Are they looking for Mercedes the car? Are they looking for Mercedes the name? And the idea might be that because we don't know the meaning, the linkage between the mark and the underlying source, might be different than in the real world, than in the usual context in which this internet or the intellectual property law has built up. And the other thing that's really different is the context here, right? I mean, when people are searching for goods and services in the real world, they very often have incurred significant amounts of cost just to begin the search, right? You go to a store to look for a particular product. You go to a car dealer to look for a particular product. You are, interested in a product, automobiles, accounting services, whatever it is, and so you are actively watching television commercials, whatever it is. Whereas in the internet context, it's somewhat different, which is you are sort of searching using keywords, interfacing with a website. The costs in some sense might be lower in terms of your time and effort. The attention that you're paying to it might be quite different. You might not know, for example, exactly what you want in the internet context, where you might know a little more in the real world context. And so that, again, points to some important issues that are quite different between the real world and the internet world, and whether or not that should be reflected in our law of trademarks, and at least how it approaches these online searching is important. Right? It's really important to understand that it is difficult to infer an intent to find anything from user selection of keywords, right? If you talk to people who design search engines, they say that people who type things into search boxes, they get it wrong all the time, right? They put in keywords that don't make any sense for what they're actually looking for. They get easily distracted and so forth, and so it's difficult to infer what exactly they're trying to do from the keywords that they've selected. And this is why most high-end search engines extrapolate from your keywords to try and determine what you're looking for using alternative keywords, for example. And so therefore the basic idea here is that we need to be careful to think about whether, when people are using language in internet context and the internet searching context, whether they're using it in a trademark-like way, right? And this, as we're going to see in a few moments, is a lot of reason why this idea of a trademark use requirement seems to have developed over time with respect to the online search context, is that maybe that's a way of understanding how we can differentiate between the real world of trademarks, where we think we understand the role that marks play in consumers searching for goods, whereas in the internet context, where we think that there's probably quite a different implication for the way that people are using language in that context, right? And so you look at a couple of searches, right? So you search for example, for domain names on Google, and you get a variety of searches and or results, right? So you get in the center of the diagram and a series of results from Google related to the Google database. And Google uses their PageRank algorithm to determine which of those results will come up near the top, which gets on the first page, and so forth, right? The advertisements are found at the very top of the page and then along the right-hand side, and those are essentially paid placement, right? This is essentially the way that Google makes money. As you read in the readings, Google sells words, so they are selling, for example, the terms domain names to a variety of players, and that sale, that purchase of that name, gets you a placement on a search page when people type in these terms, right? And that, in effect, is the money, the business model that drives Google is selling these sorts of words to companies who want to capture your attention related to the search that you are conducting, right? And you can see that it's not only domain names, which is a fairly generic type of search, but also on the right-hand side there, the Coca-Cola, right? So you put in Coca-Cola, and you see that that it's clear that there are sponsored links, right? There are sponsored links there on the right-hand side that are clearly not the Coca-Cola company. So that means that Google has effectively sold the right to be placed on a page where Coca-Cola appears, and the question is whether that's a trademark type of use, and that's something to which we're going to turn for the balance of the lecture. So let's turn to the RescueCom versus Google case. So the case here is relatively straightforward. Google is selling keywords to advertisers. We discussed this earlier. When that keyword is searched, these links appear, right? The claim that RescueCom makes a couple of claims, and one is against the selling of these keywords at all, the fact that these words appear, and indeed the RescueCom word term, you can see when you do a Google search, appears in sponsored links, so people have purchased it. It is, you can see from who the sponsored links are, that these are competitors to RescueCom, and so forth. And RescueCom has it makes an argument, and it's true that in many cases the keyword purchasers, the people who are purchasing these terms, including the trademark term RescueCom in this particular case, are going to be direct competitors to whomever RescueCom is, right? So you can see that on this search that Criterion comes up at the top of the sponsored links, and at least from the little description provided, looks like a very, very similar service providing as the RescueCom company as well, right? And then the other claim that RescueCom makes is that Google provides a service to its advertising clients, which is the keyword advisor. And this keyword advisor will actually suggest important keywords that you may want to purchase, right? So they will actually go and suggest to you, if you're interested in people using the RescueCom example, users who are searching for IT services, IT management services, computer services, RescueCom seems to be an important keyword, right? And Google knows this because they have data, right? Because they have the data on what people search for. Google knows what you search for and what you click, right? So they get a sense, they're always sort of getting feedback for themselves about whether or not, what kind of keywords correspond to people clicking on particular links. And so because of that, they can feed some of that data, that information back into the Keyword Advisor program, which can actually enhance advertisers' ability to pick keywords. But RescueCom says this is clearly trademark infringement as well, because they are in effect, showing to competitor or to users that if people or to competitors that if you use the RescueCom mark, you're going to be able to attract attention for consumers that would otherwise potentially be looking for RescueCom services rather than some other kind of services, right? So RescueCom argues that the sale of these trademark keywords, that selling the keywords that appear in sponsored links or at the advertisements at the very top of the page, free rides on the goodwill. So there's and so that Google is profiting essentially off of the goodwill built up in the RescueCom mark, right? So a sort of classic free riding argument. The second argument is that the display of sponsored links diverts and confuses consumers, right? So that consumers may believe that the sponsored links are related to the results in a way that they are in fact not under trademark law, right? That the sponsored links may be associated in some sense with the content of the search, but if you searched for a trademark like RescueCom, like Coca-Cola, like Mercedes, the sponsored links are not necessarily, and in fact perhaps not very often, the source of the trademark that you were searching, right? And then finally, RescueCom says that Keyword Advisor is just directly trademark infringement as well, right? Because this is a case study, or this is what RescueCom describes is clear infringement, because you are off using the RescueCom mark in this case in commerce. You're to sell to competitors with the intent of diverting or confusing customers in a way that is likely to harm RescueCom. So they say it makes out all the basic elements of trademark infringement using the Keyword Advisor. Right? So Google has two arguments, right? And we'll talk briefly, we'll talk in a few minutes about why they make both of these arguments. And the first argument is that there's no trademark use here, is that yes, although Google is clearly in some sense using these trademarks, it's not a trademark use. And because Google argues the statutory requirement of trademark use is not met, there can be no infringement in any event. And the second argument that Google makes is there's no confusion, right? That nobody involved, none of the search engine users, none of the keyword purchasers has any, is misled in any way or has any mistake as to the actual source of the links that they're clicking on, right? Google says we make it very clear and in a lot of ways that this is not the same as the trademark, right? There's a very clear sponsored link marking on the sponsored links. The advertisements are placed in a box, for example, a shaded box. So they argue that there's really no way that a consumer can be confused in any significant way by Google's activities here. You should note that there's a lot of these litigations going on. Some of them have been resolved, not all of them have been resolved. The law here is in a significant state of flux. RescueCom is certainly one of the leading cases, but it is nonetheless an area where the law is in flux. So the question is that the Court of Appeals for the Second Circuit has to deal with is, the district court dismissed the district court's or dismissed Google's complaint, or RescueCom's complaint against Google. Sorry, let me back up. The district court dismissed RescueCom's complaint against Google, saying that under the 1-800-CONTACTS case, which was a domain name case, the trademark use doctrine precluded RescueCom's infringement claims against Google. What the Second Circuit says here is that is simply incorrect. And in some ways, they seem to reject the trademark use doctrine altogether, although they acknowledge that it might have a role in the case of domain names. But they seem to more or less reject it here, arguing that what Google is doing here is very different than the 1-800-CONTACTS case, because Google is actually using the mark, right? So what the court says is that it's beyond clear that Google is using the mark in commerce, right? The court is quite clear, however, that the fact that Google is using the mark in commerce doesn't answer the question about whether they've infringed, but just whether they've used it in commerce, right? So what's going on here is a little bit subtle, but I want you to realize that what Google is trying pretty hard to do here is have this case dismissed on the trademark use doctrine, and we'll talk about why in a moment. And the court here, the Second Circuit here, although they don't take a position on whether there's confusion, and indeed there may not be any confusion and therefore no liability, is just not having the argument about trademark use, in part because the court seems to just not acknowledge the idea that 1-800-CONTACTS said what it said, right? So in the 1-800-CONTACTS case, the advertisers, keywords triggered advertisements, right? But that was because of an internal database that the search engine provider had that associated different trademarks with keyword results. There was no transaction there like there is in the AdWords context, right? So the court thinks this is quite a different situation where Google is actively selling these terms to advertisers, and therefore the court says making a much more deliberate choice about what kind of marks to associate with particular keywords, and indeed the ability to sell the keywords altogether is quite different here, right? And so you can see what Google says is that what the court says, and I think the important aspect is here in the middle of page 872. The present case contrasts starkly with the important aspects of the 1-800 decision. In 1-800, we emphasize the defendant made no use whatsoever of the plaintiff's trademark, and here what Google is recommending and selling is the trademark. Second, in contrast to the 1-800 case, where the defendant did not use or display, much less sell the trademarks, again, display ads popped up, but there was no actual display of the mark, right? Google displays, offers, and sells Rescue.com's mark to Google advertising customers when selling its advertising services. Again, this is the keyword advisors. And it allows not only the keyword advisor, but just allows people to purchase the keywords altogether. In addition, Google encourages the purchase of Rescue.com's mark through its keyword advisor suggestion tool. Right? It actually can suggest using the trademark. Right? Google's utilization of Rescue.com's mark fits literally within the terms specified in the statute, and according to the complaint, uses it in the sale rendered in commerce. Right. So the issue here is that the district court dismissed this on the 1-800 case trademark use grounds, and the court says no, that indeed the Google has used the mark and sold the mark in a way that's very different than the earlier cases, and therefore the court says, the Second Circuit says, this has to go back and vacates the case and sends it back to the district court. Now again, this doesn't necessarily mean that Google is liable for trademark infringement. It just means that Google is now going to have to go back, and the fight's going to be primarily on the basis of the likelihood of confusion, right? Whether consumers will actually be confused by the use of the marks, and I think that that's an open question, of course, right? And so the court sends it back to the circuit sends it back to the district court for further consideration, right? So an important issue in all of this is the trademark use doctrine, which I wanted to highlight here for a few moments, right? And so the first question is, what is this, right? What is this trademark use doctrine? The idea here is that an important component and a critical component of trademark infringement is not only just the basic likelihood of confusion analysis, but that in addition, there has to be a use of the mark in a trademark sense, right? So the idea here is that it is not actionable trademark infringement. And indeed, you can't even make a claim that could survive a motion to dismiss if it is not a trademark use. Now, this will remind you of other things we've studied in the course, like nominative use, right? Where the idea there was using a trademark in the sense of describing the underlying good or service. It's a very similar idea here, and the idea is that this is a statutory requirement, right? The difference here is the nominative use distinction, or the nominative use doctrine, is something that is judicially created, primarily one in the Ninth Circuit, is generally accepted, but it is a creature of the courts, not of the statute. And the effort here with the trademark use doctrine is to connect that idea, the idea that trademark law does not extend so far as to prevent you from referring to particular products in a non-trademark sense, that is what the trademark use doctrine is all about, right? And the RescueCom court rejects it. We talked a little bit earlier about exactly why the RescueCom court rejects it. In short, they seem to just not buy that it's a particular requirement. And the thing to ask yourself, and I think the important question here is, what's the statutory basis for this, right? So the basic infringement statutory scheme is in 1125A, right, which says any person who, on or in connection with any goods or services or any container for goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, or false or misleading description of fact, or false misleading representation of fact, which A, is likely to cause confusion, cause mistake, or to deceive connection as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, approval of his or her goods, services, or commercial activities, shall be liable, right? So the statutory basis is that word uses in 1125A1, right? And the question to ask is whether or not that statutory language can bear the weight that's being put on it, right? Is it a trademark use requirement, or is it merely a use in commerce requirement, right? Is it what Google would say that it means? I mean, Google argues, and others do, argues that word provides a statutory basis for saying that unless you use a mark in the trademark sense, you cannot be liable for trademark infringement, right? And that's what the word uses mean, right? You have to use it in a trademark sense, right? What others say, and what RescueCom, and it appears what the Second Circuit held in RescueCom, was that it's a use in commerce requirement, right? That's a requirement not so much about the character of the use of the mark, it's just that it be used in commerce in some way, again, linking it back to the constitutional basis for the Lanham Act, which of course is the Commerce Clause, right? So by that it's really a use in commerce requirement, and it's sure it is intended and in some sense does prevent certain kinds of uses, i.e. genuinely non-commercial uses. It prevents, for example, in general, talking about marks from being an actionable infringement, because that's not a use in commerce, but it would not prevent liability when you're using in commerce, no matter what kind of way, and so it would be, it would not prevent the Googles of the world, the search engines, from being liable for selling keywords, for example. It would not prevent either the band Aqua or Warner Brothers from being liable for the Barbie girl song, because again, they're using the mark in commerce. Now they're using it in a fair use sense, maybe a nominative use sense, but it is still nonetheless a use in commerce. That would be the Second Circuit's position from RescueCom. What the sort of Google position, the trademark use position is, would be that is not a trademark use because you're referring to Barbie as Barbie, not Barbie as the underlying source of the product, that is Mattel. So not as a trademark, right? And I mean, a question here to ask yourself is, why is Google in particular, others of course are doing it as well, but Google in particular is really pressing to have this trademark use doctrine developed? And why don't they just rely on lack of confusion? Because it certainly from first glance would seem like they have a quite impressive argument with respect to lack of confusion. They certainly take steps on their search pages to ensure that there's no or that there's relatively little risk that people will understand that these sponsored links, for example, are indeed sourced or associated with the underlying trademark. People, it's relatively firmly established in internet cases that people are generally not really confused when they go to a website. If they think they're going to Mercedes and instead they go to Chevy, people are not genuinely confused that Mercedes and Chevy are now the same company. That's not the case. So it seems like Google has a good argument in all these cases of search engines where they get sued for having a search engine, of saying that this is just no confusion and therefore not actionable. So why do they want the trademark use doctrine, right? And I think a lot of this has to do with the fact that if it's a statutory requirement, right, if it's required that in order to make out a claim of trademark infringement, you have to show that you're using the mark in a trademark sense, right, i.e. the trademark use requirement, then these cases are easier for Google to have dismissed at an early stage, and therefore they are much less risky and much less expensive for the Googles of the world. This makes a much more clear line for Google and other search engines, other types of providers in the online context to follow, whereas a likelihood of confusion analysis is, of course, always something that's based on facts. Now, it may be that those facts are largely going to be in favor of the search engines and they're going to win these cases, but it's a harder and longer and more expensive and potentially more uncertain case than had trademark use requirements. So I think that what is really driving a lot of this litigation is this idea of whether there should be, in a sense, a statutory, almost a safe harbor for certain kinds of uses of marks, that is, uses of marks that are not, quote, trademark related. Now, query how well we can define that line, right? How do you know when something is a trademark use versus a non-trademark use, right? So think about, when Google's keyword advisor suggests that you should purchase, the supplier of IT services should purchase the RescueCom mark. Is that a trademark use or is that a use in some other way? It's certainly not, the parody or criticism type of use that you would think is protected under the fair use concept. It's definitely a use in commerce, right? They're selling the mark. But Google would argue that's not a trademark use because they're not trying to associate any particular goods and services with that mark. They're merely trying to offer for sale the ability to land on the search page when that particular word is given, and that's not a trademark use. And so, one of the questions that I think, you want to think through is whether or not, even if we have this, what Google views as a relatively clear line between trademark use and non-trademark use, whether that is really that clear a line, whether we're going to be that confident that the courts and frankly everybody else can understand the difference between the two, and if they do, how if they can't, how useful the doctrine is at sort of providing this important safe harbor against for search engines. So finally, let's discuss sort of the underlying policy issue here, which is really how to think about trademark law in the context of internet searching, right? And so in stepping back for a minute, let's think about, what this is. This is a new technology, right? The idea that you can use the internet to search for things is a new technology subject to lots of innovation over the last several years. And it's coming into conflict with traditional uses of intellectual property law, in particular here, trademarks, right? This is, by the way, a theme we're going to see throughout the Introduction to Intellectual Property course, which is new models, new business models, new technologies are challenging intellectual property law in a whole range of important ways. And one of the questions we're always going to have to grapple with is, how do we deal with that, right? Is it the old traditional intellectual property law that's going to define the terms of this new internet world? Are we going to, in some sense, allow exceptions or exclusions for new technologies? Are we going to take a wait-and-see approach and let there be some disruption? And those are sort of the bigger policy questions to think through in this context, right? And I think in this area, there's really two ways to think about search, right? And one is this. You argue that internet search is one of the most important ways that consumers find product information, right? And in some ways, this has taken over consumer searching almost entirely. It's the modern equivalent of strolling the aisles, but it's different because you don't have the real space contextual clues, right? You don't have, the rest of the product packaging. You don't have where it is in the store, which can give you important contextual clues. You don't have size. You don't have other attributes of products that might otherwise give you a lot of contextual clues about what's going on. So on the one hand, it's important, it's it's a real way of searching for goods and services, but you do lack a lot of the real world context that comes through this, right? And so this view says, well, by manipulating search results for money, right, by placing ads at the tops of pages, at providing sponsored links, whatever it may be, search engines are free riding on the value of all of these marks, right? As that these traditional marks have been invested in over the years in the real world. And now these search engines are able to essentially free ride on the goodwill established by major trademarks by selling them, by manipulating the search results in order to highlight particular contextual clues and things like that. And they're free riding in a variety of ways. And they also might create consumer confusion about the relationship between these marks and the sources, right? Because now that the Mercedes company has to essentially share attention with anyone who wants to purchase the Mercedes trademark, the argument is that undermines trademarks in some fairly significant way, right? That in the consumer's mind, Mercedes no longer solely stands for the particular car company, that it's instead changing. The understanding of Mercedes is changing, that it's now just sort of a referential point that could correspond to a variety of other goods and services, some of them completely unrelated to cars, right? Just whoever wants to purchase them. And so that, the argument is, undermines considerably this source identification relationship between trademarks and the underlying manufacturer or provider of goods and services, right? And that ultimately you're going to degrade trademark value by allowing this to go on, by allowing this manipulation of search results, and it's going to reduce investments in product quality, right? Again, the basic idea of what we want trademarks to do, which is encourage investments in product quality, reducing consumer search costs, and thereby creating a better, more competitive market for goods and services, is going to be undermined by having search engines that are allowed to undermine the value, the connection that trademarks have. View number 2 starts off the same way, right? Internet search is one of the most important ways that consumers find product information. It's the same, strolling the aisles, although without real space contextual clues. However, this argument says, given limits to searching, consumers don't really expect this relationship between trademarks and sources, right? Given the lack of the real-world clues, the argument goes, people aren't thinking about trademarks in the same way anymore, right? They're thinking about them quite differently, right? And the consumers will often use trademarks in non-trademark ways when searching, right? So you know, it might be perfectly understandable for somebody to type in, you know, a Mercedes, even though what they're really searching for is a Lexus, because in their mind somewhere it's all luxury cars and they correspond to each other, they're competitors, and so therefore consumers are going to use trademarks in a very different way than they might in the real-world context, and the law should reflect that, right? And so the argument goes that absent some very clear link between the mark and the search result, it's extremely unlikely that consumers in this context are going to be confused because they know what they're getting, right? They know that there's not this established relationship between marks and online search results, and because of that, there's no particular worry, right? And so this is really the question, right? And the way that this structures is essentially as follows. On the one hand, view number 1 says, look, if we allow the search engines to continue without liability, right? Argument 1, those who take argument 1, will say that you're going to get reduced investment in trademarks, right? Because you're going to undermine the overall value of marks, particularly in the online context, right? You're going to reduce the investment in the internet as source of products, right? You're going to not encourage people to use the internet, or large companies to use the internet as an important marketing channel, because if people are going to be continually confused as to source on the internet, why should we invest significant sums in marketing on the internet? People are just going to be confused, right? And it's going to shift power, the argument goes, to search providers, right? That they're going to be the ones who are going to determine the linkage between consumers and source, right? That essentially, at the end of the day, it's going to be Google gets to decide what the term Mercedes stands for, because Google gets to decide what comes up near the top of the search results when you search for the term Mercedes. And Google, if they can do whatever they want, is then placed in the position of determining essentially what the Mercedes means in the online context, right? The other argument will be that if you have no liability here, if you allow the search engines to continue as is, that you're going to get more investment in search technologies, right? Search engines, because they don't have to worry about intellectual property liability, because of this, are going to continue to invest in new technologies for search. Search is going to get better. It's going to be better at associating the objectives of the consumer, of the searcher, with the ultimate results, and things are going to be generally better. It's going to increase the use of the internet as a source of products. People are going to come to the internet knowing that it's an alternative, it's a good source for finding information and indeed products, goods, and services online. And the argument here goes, this is going to have very little effect on the marks in the real world, right? That in the real world, people are still going to understand that Mercedes means the automobile. In the online world, they might understand something different, or at least in the search engine context, they might understand something quite different. But that doesn't necessarily mean that the mark is undermined. It just means they understand that there's a distinction between the search engine context and other contexts, much like you would understand the difference between the use of the term Mercedes when you're in a car dealership versus you were in, for example, the grocery store, that you wouldn't think that you were referring to the car manufacturer if you saw or understood or heard the term Mercedes in that different context. Just like that, in the search engine context, you're going to understand that these marks don't always directly correspond to source, and instead they represent sort of a broader class of goods and services. But what if we decide there is going to be liability, right? That selling these marks in this way makes search engine providers liable for these activities, right? So argument number one says, look, this is going to enhance the value of trademarks, right? Trademarks are going to become potentially even more important because they're going to have this new avenue, the internet searching, as a place where they're going to be important, and so people are going to invest more in marks. And if they're going to invest more in marks, presumably they're going to invest more in the underlying quality of the goods. That would be the whole point, right? It's going to increase the investment in the internet, right? More and more companies will be interested, particularly large, well-established companies will be interested in taking their products online, offering their products online because they feel like they can protect their marks well online, and so that you'll get more investment. And then, the argument is that the market is going to determine, as it always has in the traditional sense, what is the consumer to source linkage, right? So if there's secondary meaning offline, then there should be secondary meaning online. And consumers' linkage in their mind between the mark and the source is going to be maintained online, and therefore there won't be a third party, a search engine, in charge of this relationship. If there's liability, the other side says, well, it'll be less development in search, right? Because if you can't sell or otherwise use trademarks, then you have really put important limits on the ability of search engines to do what they want to do, and that's going to mean that they can't invest. I mean, think about if Google couldn't use their AdWords, right? I mean, Google makes almost all of their money from the AdWords program. Think about if they could only sell non-trademarked words, right? So, they would obviously still be able to sell the generic words, which are probably the most valuable ones, but there'd be a lot of words they couldn't sell. What would that impinge upon the investment that they would make in the overall search technology? I think we don't know, but the argument is that it would be less, right? They argue that if there's liability, there'd be less use of the internet as a source of products. People wouldn't think differently because there's less investment in search. They wouldn't use search engines as much. The benefits of the search engines in terms of product searching and so forth wouldn't be as apparent to the general public, and so it wouldn't get as much use as it would before. And they view that trademark law essentially allows, in the real world, mark owners to control a lot of aspects of the way that people refer to their products. And that although there are certain exceptions for parody and criticism and some nominative use, the fact remains that if you own a trademark, especially a famous trademark, you have a lot of control over the way that people deal with that mark, and that will then continue in the online context, which may or may not be a good thing. And I think it's probably too early to understand the right answer. Certainly, if you've looked at the Google page anytime recently, you can see that they've won all these cases, or almost all of these cases, and are therefore plowing ahead in terms of their AdWords, and they're making plenty of money, lots and lots of money on the AdWords context. And at the end of the day, it's certainly true that the market is just going to adjust, right? I mean, if there's liability, if there's no liability, whatever it is, the market will ultimately adjust to that. and the worst thing we could do is sort of be uncertain. And the question is what we should do, right? I mean, we could, the courts could take what they've done so far, which is a fairly cautious approach and sort of a mixed focus on trademark use. Sometimes you see them focusing on trademark use or not. You can see that the difference there sort of highlighted in the RescueCom case. But in general, I think I'd characterize the courts as taking a view of, we're going to take this on a case-by-case basis. We're going to look carefully at things like likelihood of confusion, and not make any sort of broad statements or hard and fast rules at this point, which is why I think you've seen courts, although they acknowledge this trademark use doctrine that's been set up a few times, they have not fully embraced it, right? There's a mixed focus on that. But at the end of the day, the real question here is we have this new world, right? We have this new internet world, this internet searching world in particular in this context. And should trademark law give in some sense, right? If there's a conflict between these two, who should win? Right? You could imagine a variety of ways that you could play this out. You could say basically there's blanket immunity for search providers, right? Search providers, regardless of whether you think they're using these terms in a way that is trademark infringement, we could have them have immunity, which would, the argument goes, enhance investments. Similar to them, maybe getting tax breaks or something, right? If they didn't have to comply with or worry about complying with trademark law, then perhaps there'd be more investment, more rapid growth. We would get some social benefits out of the search that might overcome the loss, if any, to the trademark, to the undermining of the trademark concept. You could also do a different thing, which is you could say in the online context, you could recognize the different ways that consumers interact with marks in the online context and say that you need a heightened standard of proof, right? That you can't simply assert that there's confusion, that the likelihood of confusion standard would be, in some sense, be higher because of the realities of the internet context, where the costs of mistakes in searching are quite low, where the investment in searching is quite low as compared to the real world. These are both ways that you could adjust the trademark law to essentially give in to this new technology of search. And I think that's an important policy question, and one that you're going to see repeated across a number of areas of intellectual property law, which is new technologies challenge the law, whether it's patent law and new technologies related to genetics and computer software, challenging our ideas about what patents are all about, whether it's copyright law and the ease of digital distribution, challenging our ideas about who should be the publisher and controller of artistic works, or here trademark law and this new concept, this new technology of search, challenging who gets to control the consumer's relationship between concepts and basically words, language, and the underlying products. And how we want to deal with that is really the issue that intellectual property law in the modern era is primarily concerned with. So that's it for this lecture, and I will hope you enjoyed it, and I'll talk to you soon.